ANC leaders, including Mr. Zuma. I confirm that Mr. Zuma and other ANC leaders approached me at the time and asked me to provide legal services to King Goodwill Zwelithini, but I suggested my partner, Mr. Mate, be the one because he had family ties with the royal family. In 1996, I did have a one-on-one meeting with Mr. Zuma in my law firm when I had been instructed by a certain client to institute certain legal proceedings against him, and we met to discuss the matter. I ended up not instituting those proceedings because I got appointed as an acting judge in the labor court before instituting proceedings, and my client had to find another lawyer. Announcement of 21 September 2020. 14, the announcement I made on 21 September 2020 was not made in a media conference. It was made at the commencement of commission proceedings on the day when Mr. Zuma was supposed to have appeared before the commission. Mr. Zuma's attorneys had, prior to that, sent the commission a letter dated 1 September 2020, a copy of which is attached marked AA. It also occurred after the failure by Mr. Zuma to comply with a Regulation 10.6 directive dated 27 August 2020, a copy of which is attached marked BB, and giving no explanation why he had not complied and not applying for an extension of time. That is the end of the statement. Copies will be made to and given to counsel and all concerned. I place on record that although I discussed with counsel the statement in chambers, they had not seen it because it only got ready this morning. But I mentioned that I would read it and I would circulate it to counsel. Thank you. Mr. Skakane. My registrar must just make sure that copies are given to counsel for the former president.
Chairperson, thank you for your opening statement.
Thank you, Mr. Skakane.
I would like to get a couple of things out of the way.
Yes, yes.
Partly because...
But I must also, before you do that, I must also thank you and your team for understanding with regard to the statement that had not been given to you in advance.
Thank you, Chair. We will look at it.
Yes.
You make a good point in the statement about the relationship.
Yes.
You contextualize it.
Yes, yes.
And of course, we know that in recusal applications, there is something called a waiver. It means you didn't raise it at the beginning. And so, although we're going to look at your statement, and I'm not going to cross-examine you about it. Chair, I thought I should get a couple of things out of the way because this matter has been talked about, and a lot of people have pontificated about what it is we're doing. And I thought this opportunity I must use first to say, contrary to public speculation, we advised and brought Mr. Zuma here to demonstrate to you that he was never going to defy you because he understands the nature of your job and respects the summons that you issued, and he was never going to defy that, even if we told him to defy you. Secondly, Chair, since the letter of 28 September 2020, which indicated that we would bring this application, so much, as I said, has been said out there, and most of it has been an attempt to deal with a subject that even scholars, legal scholars, tell you how difficult it is. because it's not an open and shut case. Recusals are difficult. And they are difficult because in order to approach judges as I do today, you first must approach someone you respect, which I do, and you must tell them that you think they have made errors. And it's no easy task. And this subject is difficult because the precedent, as I will rely on SAFU, as you've already mentioned it, I have my own difficulties with SAFU, because I do think one judge should have recused himself there. But be that as it may, I will raise these because they are difficult. They're not as easy as analysts and journalists have been saying, partly because the rules, the precedent, are set by the judges themselves, judging those who judge them. And so judges create rules of how we should judge them. And they tell us, they remind me of someone who gives you a slap and tells you how to cry. And so they're difficult for that reason. And I'm going to raise today a number of things because first, Mr. Zuma does not do this lightly, we say this. And unlike many recusal applications, which go to the integrity of the judge, both my team and Mr. Zuma would never come here to say the reason we're asking for your recusal or a way to deal with this matter in a particular way as I'll deal with remedy. It's because our application is about your integrity. That is unquestioned by me or Mr. Zuma and Mr. Zuma. Lastly, Chair, a number of issues have been raised about whether or not this can be brought and whether we are attacking you. Well, Chair, I don't need to remind you that none of the people who've been making that analysis on television, claiming all sorts of things, are as close to you as I am, or are as related to you as I am, or would defend you as I would. So none of them can claim that I would bring a frivolous application to you to question you, let alone the fact that we come from the same village. Chair, that is what I thought I should get out of the way, because there's a misconception about this by people who think they are defending you from a Zuma attack, which it is not. And Chair, what I'm going to do in relying on the principles about recusal, as I said, they are difficult because many think we raise this because we say you are biased. And we've set out in the affidavit that actually that is not the test. The test is whether a reasonable person sitting in an environment that we lawyers take for granted because we are familiar with it can apprehend that he's not going to get a fair hearing. Now, that has nothing to do with the integrity of the judge. The next issue about that is this. When you raise a recusal application, one of the things you're saying to the judge, which is the most difficult part, not just because of judges, because human beings are not good at self-reflection, is to ask the judge not to check whether he has integrity, but to ask the judge to dig deep into his or her humanity, to check whether, given the hostile environment for a witness, his conduct, I don't like this word because it's associated with something bad, but his demeanor, his comments, and it's not because, I'm not going to list your comments because I think they are bad. We lawyers do this when we cross-examine people because we take advantage of our powerful position and we forget that they are vulnerable. And so, as much as I'm going to rely on these principles, largely a recusal application, Deputy Chief Justice, is brought to a judge precisely because you trust them. It's brought to that judge precisely because only a judge with integrity can sit and listen to him, to people telling him that he may have made a mistake. And I want to say to you, Deputy Chief Justice, I will as I've done in the affidavit, look at your comments, and the context of those comments is that as much as this environment is easy for you and me and Mr. Pretorius, it's not easy for a client or an ordinary citizen who's sitting as an accused. Because it doesn't matter what we say about Mr. Zuma. The narrative is that he sits as an accused. And therefore, that is the context within which you must look at his apprehension about this commission's choice of witnesses. This commission's comments during testimony of those witnesses. This commission's approach to issues that he has raised to the commission. And as I raise those, I also raise the fact that for a person sitting, watching a powerful environment in which he is the accused, basically, I want to persuade you, Chair, first, that I want to walk with you and look at your comments from the perspective of a person who sits watched by millions of people who thinks he symbolizes corruption. And that is the context. So when the test says, let's look at the reasonable person, your chair will see, I will share this with you because it's something that gets missed in the analysis, is that a lot of scholars like Grant Hammond and others, let's forget the judgment, the judgments, tell you that a recusal application and the test that a person must be a reasonable person is also context specific. And the context I'm giving you is a Mr. Zuma, who all of these people sitting here, most of them journalists, the narrative they've come for is that here is the man who messed up our country. That narrative on its own, I don't want to get into its merits, is the context within which Mr. Zuma views this environment. And therefore, the test about a reasonable person who's not too sensitive is also the test, as in the Commonwealth they say, of a reasonable lay person. Not a lawyer, not a judge. Chair, I'm going to address 3 things. The last of which is what you would love me for, because it's about how do we get out of this? It's about remedy. How do we get out of this and have a commission in which each and every person, particularly the person who was central in the remedial action, you finish this with his contribution and without him fearing, as he fears now. And that I will discuss with Chair right at the end, because I think apart from the animosity out there, which is political, you and me have a duty to ensure that a legal process called a commission inquiry, whether other people see it as a political platform to destroy their enemies, is not our concern as lawyers. Our concern is R1 billion or so has been poured into this process. Are we going to be fair if at the end that report is driven by a narrative which simply accepts that there's one version? So the first issue I'm going to raise, Chairperson, is to take you through the cases.
Just 1 second before you do that, Mrs. Kakane. Sorry about that, Mr. Skakan.
No problem at all, Chair.
Thank you. You know, you said you are now going to take me to the cases and so on. So I had a particular copy of SARFU that I had looked at. And, you know, when you look at one on which you haven't made any underlinings, it's not as helpful as the one that you have used. But that's fine.
Chair, I will, depending on what the chair, I have a file of the cases that I will look at. It's the cases that the chairperson knows, but I can share that file.
No, that's fine. No, I particularly just wanted the SARFU, but I'll get it because I made some notes.
Thank you.
But it's fine.
So, Chair, what I will do is to first summarize those. That's the first thing.
Yes.
Having done the intro, I wanted to get those things out of the way.
Yes, okay.
Because they are important to note. And to deal with the principles of recusal as they emerge from literature and legal scholars and cases. And I will tell the chairperson why I'm very reluctant about case law on recusal. As much as it guides us, it's actually unreliable because it's judges telling the world, when you judge me this way. There's something intellectually dishonest about that theory. But be that as it may, I'm going to take you to the principles so that we can debate whether we meet the test. Second, I won't dwell much on this, Chair, but I want to trace the genesis of this commission. I've done it in the affidavit, we have it, and so I will not waste your time on that. But I do this because contrary to popular views out there, and I've heard it the very first time we wrote the letter, or the Mabuza wrote the letter, there are a lot of conatists and analysts speaking about this, saying you don't do this in a commission of inquiry. Chair, I'm going to do this for one reason. One has to read the remedial action of Advocate Thuli Madonsela and the judgment of the North Gauteng High Court to know that the reason the executive, the president, who has the constitutional duty to appoint a commission of inquiry, had that task removed from him was precisely because impartiality, or the perception of impartiality, was at the center of the appointment, of the establishment of this commission. So no analyst should tell our public that when it's a commission of inquiry, impartiality is not important. Secondly, we ask a judge to lead it. Because, Chair, you can never strip yourself the principles and your oath just because you are now leading a commission of inquiry into soccer. The reason we ask a judge is to borrow from a profession whose ethics and standards of impartiality are slightly higher than the ordinary person. And so, the third issue I want to deal with, and probably the last, before I deal with remedy, is to take you to your comments that have raised concerns during these proceedings. And we raise them not because those comments, as I said at the beginning, mean you're going to find in a particular way. Because there are recusal applications that deal with the fact that there has already been an outcome. I think most of the cases, the BTR, Delaisi, and others, all of those cases tend to deal with the situation when a person post facto is unhappy with the finding. And there are other recusal applications where people say, this judge has a personal interest in the outcome, either pecuniary interest or it's an interest in the outcome because you are aligned to it. That is not our contention in this matter. We don't make the submission that you have an interest in the outcome and therefore you will go that direction. And so what we do, Deputy Chief Justice, say to you is that reduced to its essential elements, this application seeks to persuade you. Maybe it won't be for Mr. Zuma, but for the continuation of this, to look honestly and sincerely at some of the comments that we will identify, and we contend to you that they would frighten a litigant who's sitting, not a litigant, a witness who's sitting before you. And Chair, here are the principles that you and me know as a test for bias. But as I indicated to Chair, let's start with bias as a concept before we get to reasonable apprehension. Is that the difficulty with bias for psychologists, for lawyers, for human beings, is that it straddles two domains, at least for your purposes. It straddles the domain of law and the domain of psychology. And that's what makes it difficult. I say the domain of psychology because I'm appealing to your psyche. I'm appealing to your honesty about your own errors. It's law because we look at how to tighten claims of bias that are raised by lawyers and litigants simply to disqualify a judge. And so it's important that we make that balance. And because it's not made clear. So bias is a state of mind. But what are we to do when we ask a judge to recuse themselves because we have a reasonable apprehension of bias? Well, there's a case, it's R versus S. It's a Canadian Court of Appeal case, Chair, which accepted the definition that is in R versus Bertram about defining bias as a start. It says, it's a leaning, an inclination, bent or predisposition towards one side or another, or a particular result. In its application to legal proceedings, it represents a predisposition to decide an issue or cause in a certain way which does not leave the judicial mind perfectly open to conviction. Bias is a condition or state of mind which sways judgment and renders a judicial officer unable to exercise his or her functions impartially in a particular case. Let me make an example for your purposes. Chair, let me make this example. Our judges in criminal courts sit and listen to the most gruesome crimes. Gruesome, more gruesome than what our judges in the civil courts listen to. And I think the public and you and lawyers who are honest will agree with me. Those judges sit, compose themselves, keep quiet, listen, rarely comment for one reason. Because they understand that once you comment and you show outrage in one way or the other, you create in the mind of the person who's sitting vulnerable in your court or your forum an impression that they are right inside their slaughterhouse. And so, Chair, I'm citing our magistrates and our judges in criminal courts because they master this. They keep quiet when someone is testifying about the rape of a 2-year-old. They keep quiet, compose themselves. Our judges in the civil courts throw their hands in the air because there are no board minutes, because people may have stolen money. I'm not saying that crime is small. What I'm emphasizing, DCJ, is the obligation to create in a forum an environment that does not frighten a witness. That is bias, it's that inclination. And therefore, as I will show in your comments, when Mr. Zuma is sitting watching at home, the narrative playing itself here that his years of presidents were 9 wasted years, and he watches the chair.
Of course, I haven't said that.
No, Chair, you haven't.
I have not said that.
Chair, you will understand that most people believe that what we must do for my client is to give him orange overalls and walk him to Hoshimakuru prison. But I'm raising this because, Chair, I'm not saying you've said anything of that nature, and I'm not suggesting you've prejudged this matter in any way. I'm saying to you, in your comments in his absence, I want you to walk with me and look at whether a reasonable person, accused as he is, it would be unreasonable of him to feel that the forum seeks to punish him, seeks to lynch him, seeks to agree with people who've come here to lynch him, basically, seeks to agree with the political project to destroy him as a symbol of a particular political narrative in society. And therefore, for me, that is the test we must use. Now, in the same case that I've quoted, in the Court of Appeal, it accepted that partiality can be described as the inability of the decision maker or judicial officer to prevent his or her biases and dispositions in conducting the matter or making a decision. That's not where we are, Chair, because it's not about the decision. And therefore, we're not dealing with whether or not your decision is necessarily tainted. We're not there. We submit this, that this inability that is stated in R versus S in the Canadian Supreme Court, Court of Appeal, is akin to the South African principle that despite his or her bias or predisposition, the decision maker or judicial officer must bring an open mind. So that, Chair, that is an acceptance that all of us in this room are biased, including judges. And the reason people are appointed judges is because they are slightly more honest than we are about their biases. They have the ability to confront them. And so what emerges from this case is the fact that what is asked for in a recusal is self-reflection. And very, very few human beings have that. Lawyers, politicians, and journalists are the worst. And so what that principle tells the chair is that the inclination that it talks about may well be justified outrage. I'm not going to stand here, Chair, and tell you that you are not justified to be outraged by some of the things you hear. You are. What I'm asking you is, in that outrage, like the judge listening to the rape of a 2-year-old, what are you supposed to do? Now, before I get misinterpreted as conflating court and this forum, Chair, it doesn't matter what forum it is. I understand fully that in this, you have a difficult task here than you have in your court. In your court, you must make a decision based on what's in front of you. Commissions of inquiry are difficult because they turn a judge who's supposed to coldly look at the facts and make a finding. They turn you into an investigator. So they are both adjudicative in some way and inquisitorial. And in a way, you have to strike that balance, and I appreciate your difficulty. But I honestly suggest to you, through the quotes that I will make, Chair, that there have been times when even I, sitting watching, have thought the DCJ has crossed that line. Not of bias, but the line of how to express outrage when you hear it as a presiding officer. And Chair, the last point is actually made in the SAFU case, that, so that we bring it closer to home. Chair, I said it in jest earlier about SAFU. I know it's the final decision that was made and it can't be appealed, but we can criticize it. because it's a very big subject. In fact, the last author who's produced a book on this subject, as I said, Grant Hammond, it's new, tells us in his last chapters that this is not open and shut for intellectuals, for true intellectuals. It's not. And here is what happened at SAFO. The chair said earlier that, and correctly read the statement because that principle comes from it. And of course, the principle they say is this. They say at the beginning, at paragraph 35 of the judgment, a cornerstone of any fair and just legal system is the impartial adjudication of disputes, which come before the courts and other tribunals. This applies, of course, to both criminal and civil cases, as well as to quasi-judicial and administrative proceedings. I pause there to make this point because our public has been fed this narrative by people who want to see their faces on TV for 2 minutes to say impartiality is not required outside court. And so it continues. It says, nothing is more likely to impair confidence in such proceedings, whether on the part of litigants or the general public, than actual bias, which is not our case, or the appearance of bias in the official or officials who have the power to adjudicate disputes. This rule against bias is fundamental in our system. It's fundamental whether we are accusing Mr. Pretorius where he works, we want to discipline him. Every human being facing a tribunal at work requires impartiality of the adjudicator. We submit that an affected person, or let's say directly implicated in our case, the applicant is entitled to an impartial commission and chairperson. In this regard, we make the point that it is the comments and conduct of how he is treated, singled out, subjected to press statements, that singles him out to fear the platform. And in the case of Delil and another, versus Speaker of the National Assembly, the following is said, paragraph 16 thereof. There is another fundamental breach of the common law rules of natural justice by the ad hoc committee, namely the nemo ex insua causa rule. This rule requires that an affected party must be heard by an impartial and unbiased tribunal. For purposes of the rule, there should not be a reasonable suspicion that the ad hoc committee was biased. So equally important is that the commission and the chairperson are obliged to observe natural justice principles, because recusal applications have their genesis in the trust that natural justice governs all legal proceedings. This is because, and it's been said in each and every case that I've cited, the South African cases included, this is because they must not only mete out justice fairly, but must be seen to be doing so. And Chair, that is important because of what I said earlier, of creating an environment that would make this report you're going to produce not a report that political enemies out there expect. I mean, we can tell now what Mr. Zuma's political enemies want the report to say, right? He was responsible for state capture, 9 wasted years. That's what they want. And if you don't say that, Chair, they will review you. What we want, and I think everyone who thinks honestly about this without prejudice, without hating, is that this report must be able to assist our nation in future against possibilities of plunder, not by one side, by everybody. No one, when we make policy in future, must be able to do whatever you will find has been done. I assume that the chair hasn't found so far.
I haven't found.
Absolutely. And Chair, I'm going to raise this point again about justice and what we need here. And I'm going to quote a theorist, a political theorist and a lawyer. I've been quoting judges. Rosa Luxemburg says something about a right called freedom of expression, exercised by journalists and us and everybody. At the end of writing about freedom of expression, Rosa Luxemburg says, actually the right to freedom of expression is the right that should be enjoyed by people we dislike and disagree with. Close quote. Justice, and this is my quote, we are not just when we are judged against how we treat people we like. The real test about commitment to justice by a judge, by a citizen, and anyone that is worth the term human. Justice is how you treat those at the bottom of your pecking order. How do you treat people you despise? How do you treat a man that you've already assumed messed up your country? That is justice. Do you treat him humanely when you've brought him into a process? And that is what these cases are about, is we as lawyers and judges have to guarantee society that when people walk into this process, they are judged out there. People don't need evidence that Mr. Zuma was corrupt. They've written about it. They say he is. That's the political game. Here, because we are a modern society, Mr. Zuma, even if he is at the bottom of the pecking order of people we like, it is how we treat him that we are judged about our commitment to justice, not how we treat the darlings and sweetheart witnesses that have come here pretending they were not party to what they are saying, telling others to connect the dots except their dots. It's how we treat every witness. And so, Deputy Chief Justice, that principle is what guides what we're saying. And the test, as I said, has two components. One is the one I said I dislike because it's judges telling those who judge them how to judge them. It's impartiality. And one of the difficulties I have in this court, apart from the fact that I'm the first one briefed to tell the second in command in the country's judiciary to recuse himself, is that I have to climb the mountain of the presumption of impartiality. And I accept that that is a mountain to climb before any recusal application. And it goes like this. I am supposed to presume that you are impartial. Doesn't matter what you do, I start there. And so that presumption is important. And that's why I started where I started, Deputy Chief Justice, that this is not about your integrity, because I assume your impartiality as a person. And then the second leg of this test is what gets murky about when am I reasonably apprehending that I am not having a fair forum. And this must be judged, Chair, not from the position of those who love Mr. Zuma, who have affection for him, no. Nor must it be judged from the position of those who seem to have a natural antipathy towards him. Those we should discard, both those sides, because they want nothing that law wants. What we must test today is whether a reasonable person in the context of how this commission was started and how Mr. Zuma has been defined when coming here. That's the context. And the reasonable person is a difficult concept because it introduces the context I'm talking about. And that context is not generally applicable to everybody. It's it's specific to a particular litigant. But I accept that it's an objective test. And so, Chair, that is why when they say in SAFU that, and in many other cases, the principle is like in defamation. We should not judge this because Mr. Zuma or any litigant who seeks a recusal is a hypersensitive human being who just wants to walk into forums that are friendly to him. That type of person is not the reasonable person. The other is what you find in the other cases, the BTR and others, where lawyers themselves and litigants who've lost or seek a forum shopping seem to come with spurious things to judges just to get rid of them. One such case here, I think, is a case where people simply said, I didn't like the judge's demeanor. He was talking to me in a rude way, right? And so what the test tries to do is to balance those extremes and abuses of the legal system by us, lawyers and litigants. And so it says that we must judge it in a manner that takes into account the context which I've explained, and the person must be reasonable. Chair, I'm going to say reasonable because only yesterday, a lot of people got into this forum today about whether Mr. Zuma will come, because there's an assumption, I don't know why, there's an assumption that he won't. And that context, Chair, is important when you analyze what is reasonable for Mr. Zuma as he faces what you will see tonight on TV, because he can do no right. That kind of litigant sitting before you has his context about this forum, and I want to invite you to look at yourself and the comments that I'm going to raise that you made, not because you were judging, but because you may have created an environment that enforces in his mind, reasonably so, that this forum is an extension of the narrative about him, that everything wrong in South Africa is attributable to him. And Chair, so what is the real test that you have to do when judging this? Apart from the fact that I'm going to rely on your capacity for self-reflection, is that the starting point is an analysis of how does this commission start? Who is central? I've been told by 2 courts already that no, the reason the function of the executive was moved to the judiciary is because Mr. Zuma could not be allowed to appoint a judge. I'm not raising this because it's a ground. I'm raising it because it's a context you must take into account. I've been told by 2 courts that they don't presume impartiality on their part, that a judge appointed by Mr. Zuma would have been partial. I've been outraged by the suggestion because I've seen judges not relying on the presumption of their own impartiality. And therefore, that context for Mr. Zuma and the history when he's removed from a decision that he thinks he must make is the first start. And so, Chair, that context, when you analyze the reasonableness of his claim, is important. In BTR, they deal with actual bias, actually. And the AD said actual bias in the sense that the litigant then, he had approached the issue before him with a mind which was in fact prejudiced or not open to conviction. Chair, this is a bit too far, and it's not the case I'm making to you. The case I'm making to you is slightly lower than that. It's a case about conduct and comment. And Chair, without any waste of time on these principles, because they all evolve around the same, may I say to the Chair, the Bennett versus Absa Bank case as important as it is, it talks about shares, a judge who had shares, and therefore has no application here. But it may be important for the chairperson to look at it. The other case that we rely on is the Sakau case, where the Constitutional Court slightly expanded the test for recusal against the judge. And may I just read this, and then the other cases I will cite for the chair to note, because you were part of some of them. Oh. I think.
Okay.
But I'm not going to ask you to recuse yourself from those. Chair, it says, in formulating the test, this is paragraph 12 of the Sakau case, in formulating the test in the terms quoted above, the court observed that two considerations are built into the test itself. The first is that in considering the application for recusal, the court as a starting point presumed that judicial officers are impartial. I've already stated that. As later emerges from the Safu judgment, this inbuilt aspect entails two further consequences. On the one hand, it is the applicant for recusal who bears, as we do, the honors of rebutting the presumption of judicial impartiality. On the other, the presumption is not easily dislodged. It requires cogent and convincing evidence to be rebutted. When I said I have a mountain to climb, I meant this. And Chair, I say this because many of us would argue that a slight comment by a judge, I mean, many of us have faced more cantankerous judges in this country, and you're not one of them. And we know they make comments about people, but let me give this example. If you went on a Rule 43 application in spousal dispute about maintenance, and you sit there as a mother asking for maintenance, and the judge flippantly said, you know, you women are gold diggers. Of course, that comment, Chair, does not mean the judge will decide in a particular way. He can say, no, I was just making comment. But I want you to put yourself in the shoes of that woman with kids who's asking for maintenance, for survival, hearing a judge say, you know, you guys are just gold diggers. That comment, even if it comes from a, let's call it a flippant place, it was you misspoke. The fact that you misspoke does not reduce the effect of your misspeaking to the litigant who's facing a barrage of situations. And so, Chair, I won't go to the test for actual bias because I don't have to meet that test. Chair, I want to take you, and the other cases, as I said, is the Shabalala case. I would like the Chair to look at that. The other case that the Chair has already mentioned is the Safu case. Chair, may I suggest as well, because I'm not being disrespectful to judges and their judgments, is that literature by legal scholars who are not judges trying to defend themselves is much more important here. And I can share with the Chair some of the literature that comes from someone who's not a judge, who's a scholar, who's not trying to defend the club, the class called judges, because they are much more objective in the tests. The last chapter of that book, called Judicial Recusal by Grant Hammond, has a whole reading about what route to be taken, because it recognizes that this matter has not been debated as thoroughly as it should be, because the leaders of the debate are the subjects of the attacks. And Chair, so what have you done? What exactly have you done that has caused us to come here? What have you said that has made Mr. Zuma believe reasonably that this forum is not good for him.
Before we get to that, and maybe we will take the adjournment and then
As the
after
chair
that,
pleases.
but I wanted to raise we will go to the comments as you have indicated in due course. You know, when I was still new in practice as a lawyer, going to the lower courts, appearing full of enthusiasm, coming from university, and one of the experiences I had in some of the courts in which I appeared were cases where I would appear before a presiding officer and I present argument, and the presiding officer just keeps quiet. I go on and I quote authorities. In this case, this is what happened. In this case, this is what happened. These are the principles. The presiding officer just sits and keeps quiet. I never get to know whether what he or she is thinking. I would never get to know. And then maybe one question there, but sometimes no question. And at the end of argument, either immediately or later, judgment is given. And when I read the judgment, I say, I don't think he or she understood the argument. If only she had engaged me and questioned the submissions that I was making, because then we would have had an engagement and I would have clarified some of the things.
Yes.
Of course, somebody sitting there could say, oh, this magistrate or presiding officer is very impartial. He said nothing, she said nothing, she just listened, But I must say that I preferred those who would question what I'm saying so that we could engage in a debate, because then I could tell if I was persuading him or her. And also I could tell when he or she puts up a point for which I have no answer, So when you get the judgment, you feel that, look, I was heard properly, because whatever difficulties the presiding officer may have had inside as I was presenting my argument, he or she verbalized them and I was able to address them. But the one who keeps quiet throughout, you might think she or he has no problem. But maybe she does have problems, but she doesn't tell you. And you feel the unfairness when you see the judgment.
Yes,
so, but I raise this point in relation to the issue of comments, to which we will come, to say one of the benefits of the commission proceedings being televised and so on is that persons, whether implicated or not, can listen or watch as a particular witness gives evidence. And sometimes I put certain questions, I put certain remarks, because I'm thinking when the person who is being implicated comes here, hopefully they are listening or they will read the transcript. I want them to know what was going on in my mind as I was listening to this witness, so that they can address it. I'm not hiding it from them. Sure. If I like, I could just sit quietly, don't indicate what I'm thinking, but the benefit to the implicated person if I speak is that they can, when they come and say, you know, Chair, when this witness who implicated me was speaking, this is what you said. I want to take this opportunity to show you that that's not the position. So it's at least it's meant as part of transparency, rather than just keep quiet and say, so this person that they are talking about is such a bad person, but you know. So I just mentioned that.
Yes, Chair, I appreciate it.
And you may.
Chair, can I say a parting shot to
sure.
that? I wouldn't differ with you on all of that. The reasons all of you are called judge is because the term means, unlike me and everybody here, being a judge is a centrist position. It requires you not to go for those extremes, but to seek to strike that balance, because sitting quietly and doing nothing, I only have a Zulu word for it, ukduba. It means you've decided, you don't want me to talk, so I'll sit quietly and say nothing. That too is wrong. Over comments that are made flippantly without self-restraint have the same effect. So a judge who decides to go either extreme may be immature to say, because I'm questioning your comments, all right, I'm going to sit and say nothing. What is required are comments that seek to understand, to intellectually engage. But what we're raising, let me tell you, Deputy Chief Justice, because it has happened to me. I go for Mr. Zuma to many courts. Only once, and I've had a lot. I've had a judge doubt my integrity, that I'm corrupt because I represent him. Now, those are comments that you don't want, because you can be engaged intellectually for the whole day. I don't mind. What I mind is when a comment crosses that line. And I think for a judge too, there is something about being called judge that is about striking the balance in society about extremes. And we make those as examples here, not because of any malice.
No, that's fine. Let's take the tea adjournment. We are at 18 minutes past 11. Let's resume at 25 to 12.
As the chair.
We adjourn.
I can get busy with some of the stuff. And that's good for everybody. Of course, everybody. Not like they don't. No.
I would like to get time to consult with him, because as chair will agree, it is possible that the two of you have different versions about that relationship. But I have no instruction at the moment, I have no time. I just ask the chair that after today or tomorrow, I may have time, and I will tell my learned friend Paul if it's uncontroversial. Your versions about the two of you, your versions are consistent.
Yes, no, that's fine. I think in the Sarfu matter, the statements were given by the Justice of the Court to counsel, and it proceeded. Counsel and their clients accepted the statement of facts. So that is what happened.
Chair, yes, I'm not even suggesting that there's something in it. I do want to just, at least for the integrity of the process, to do that.
Okay.
Chair, the grounds that we've raised in our affidavit, in Mr. Zuma's affidavit, or the other issue, Chair, there's a replying affidavit.
Oh, yes.
Prof. Musala filed an affidavit on Saturday. I'm not sure much turns into it, but we've answered it. I want to place it on record. It's unsigned at the moment.
Let me have it. But from what you say, it looks like I might not need to bother to read now.
Chair,
because you don't say much about it in your...
Chair, we don't, because it's done this morning. And two, quite frankly, this is not one of those cases where we're going to deal with, it may rely on how we deal with the principles of Plascon events. But that's why I'm saying the difficulty of your statement is if my client tells me that your version is not consistent with his.
Yes, okay.
Yes, Chair. Chair, you will see that in the affidavit, this process where we deal with the grounds is set out from paragraph 33 of the affidavit.
Yes.
Chair, what it does I don't want to take the chair to read, it's paragraph 33 up to, I think, paragraph 47.
Yes.
Without reading that, what that ground says, considered together with all the other ground and the pattern that they form, is that when this commission started,
I'm sorry, I just want to make sure I've got the right page.
Yes.
I think I went to 33 at the bottom, but you meant 33 at the top.
Yes.
The red numbers.
Yes.
Is that right? The red numbers.
The page. I'm looking at paragraph 33 of the of the affidavit. I'm sorry, Chair.
Okay.
Chair, you won't need to go there. I'm hoping to summarize these rather than spend too much time on them. Is that, Chair, I'm raising this first ground because on its own, it's a weak ground. On its own. If I were to bring this case to you simply on this ground, and I'm saying I want you to look at this ground in the context of the other grounds and how this whole thing started and the pattern that it takes. Chair, Mr. Zuma submits that this commission, when it started, as he has said before, is that it starts because he is alleged to be at the center of a crime that is not found in any other statute in South Africa. It's called state capture. Of course, we all know it's not in POCA, it's not in Criminal Procedure Act. It's a political concept that political opponents have created to deal with misdemeanors of the other political opponents, but it doesn't exist in law. And of course, I know that, Chair, you fetched 2 or 3 experts from America, the most captured state, to come and tell us the dangers of this crime. Now, how do we identify witnesses? From the position of my client, this commission starts with witnesses who align themselves with the narrative, with the version that there is something called state capture and Mr. Zuma is responsible for it. If the chairperson looks back at the witnesses that were picked by this commission, and the reasons may well be good, I don't know the reasons. When a state is captured, Chair, suppose, I hope we never get there in this country. When a state is captured, you need a wide range of perspectives about what exactly happened in it. You don't need to call only Barbara Hogan and Pravin Gordhan and Mcebisi Jonas, who are proponents of that theory. If intellectually you want to deal with this subject, because it's not a legal subject, it's purely a political concept. Our suggestion is that the commission lined up right at the beginning proponents of this theory called state capture. And I'm not suggesting that Mr. Zuma should have been called first for his version. I'm suggesting that if one really looks at the beginning, the first days of this commission, we were listening to horror stories of people on the rooftops telling us they are not corrupt, they are angels. There is this thing called state capture. They may be right. But that selection of witnesses by a commission, by this commission, for a very long time, who parrot one version, gives the impression that a decision, that their version has been accepted, that there was state capture has been accepted. And so that selection on its own, even in the cabinet, if we look at the people who were picked to come to this commission and spend 2 days truly spewing their political theories about their opponents, it was people who are proponents of a particular narrative in the South African body politic. And I'm not saying they are wrong. I'm saying this commission lined them up in a way that is unintellectual, that would not have encouraged debate about this difficult subject. And therefore, my client, sitting at home, having been head of state, listening to witnesses, most of whom are people who have an axe to grind with him, either because he fired them or he didn't intervene in some HR issue they were involved in. Truly, that selection created an impression that a particular version may have been accepted. What you will find in those paragraphs is that we cite at paragraph 35.1 up to 35.9. And I do not really want to denigrate those witnesses because they didn't select themselves, I hope. Is that if you look at them, Chair, the ones I picked and the star witnesses of this commission when it started, Mr. Pravin Gordhan, Mcebisi Jonas, Nhlanhla Nene, Ngwako Ramatlhodi, Feiki Mento, Trevor Manuel, Barbara Hogan, Themba Masego, and Fikile Mbalula. Right? And I want to be clear, I am not criticizing the testimony of those witnesses. I'm saying if one looks at what they had come here to say, is a particular narrative about Mr. Zuma. This commission, the question may be, what could it do? Because, Chair, you were at pains asking people to come. And I think you were at pains because you wanted all versions, but they were not coming. But of course, we know that your commission could have gone to different people in that cabinet, some of whom have a particular opposing theory on this subject matter. I don't personally agree intellectually with the two theorists you brought from the US, and I would suggest that their version is not the end of the story about this difficult concept. So that's the first ground. But as I said at the beginning, this ground is weak on its own. You see it when you look at the pattern of other things. And so the first ground, Chair, was that selection lined up people that truly had a gripe and an axe to grind with Mr. Zuma.
I recognize the concession. I don't know if it's a concession, but the point you make that standing on its own, this is not your strongest point.
Absolutely.
But I do want to raise this question. Is it open to a witness or a person such as Mr. Zuma to complain about those, or what emerges from those witnesses in circumstances where he had the opportunity to apply for leave to cross-examine them and get somebody like you to basically deal with their versions, and by the time they leave the witness stand, there's a complete picture that has emerged from the picture they may have painted at the beginning, but chose not to do so.
Yes.
In other words, there may be an argument that says it doesn't matter what sequence different witnesses follow in being brought to give evidence, as long as there is a fair opportunity given to the people they implicate, for example, to challenge their evidence and cross-examine them and show them to be persons who have maybe some gripe with them or some cause to settle. That's why they say A, B, C, D about them. Of course, if you don't do that, to come and actually cross-examine them, challenge what they have to say, whatever evidence they have given might remain in the minds of the people, whereas if you had used that opportunity, what would remain is what the picture looked like after an effective cross-examination.
Chair, you're taking me to a complaint about you I didn't want to raise because it's not here.
Yeah.
Is that, Chair?
Yes.
You know, had I applied to cross-examine Mr. Jonas, who spoke for 2 days, and it has happened here, I would have been given an hour to deal with someone who speaks for 2 days.
Yes.
Insinuating my client.
Well, not necessarily an hour. What is done is, I think actually the counsel who cross-examined him ultimately cross-examined him for no less than 2 hours. But, an application is made, an argument is addressed, and we take into account what you have to say.
Yes.
Very often, I've said this recently, very often counsel who have cross-examined have been able to cross-examine within that hour or 2 hours. I can't remember. I remember one, I don't know if it's the one who was cross-examining Mr. Jonas, who had some concern, but the discussions ended up with him saying, no, it's fine, we can send some submissions.
Yeah.
So the idea is to try and strike a balance with taking too long, but at the same time, try and make sure that there is fairness. So you would have applied, Mrs. Kakane, and if an hour or 2 hours was not enough, we would have looked at
Chair,
it.
I digress. It wasn't fair of me to raise that complaint to you because we didn't apply.
Yes.
But the point I was making, Chair, I think it's because you and me are lawyers that you say that the order doesn't matter. Chair, the order does in environments of this nature where for 2 years you call people who parrot a particular narrative about people. It may not apply to you and me as lawyers because we sit here and deal with cases and we forget about the world of propaganda out there against human beings. But I think when you line up witnesses for 18 months who parrot a particular version in an environment of this nature about somebody, it may have an effect on them. But the point I wanted to dispel, Chair, because we've seen letters from Professor Musala, for instance, and before that. This notion, it ended at 12 last night, and the last statement that Mr. Zuma won't come here was issued by some foundation related to one of the witnesses. This issue that Mr. Zuma refused to come here, Chair, is with respect false. It's untrue. What has happened in this, I'm not saying the chair is telling a lie, I'm saying
Yes.
it's peddled that Mr. Zuma, it's in the papers of this, of this commission, letters to us, asking us, even incompetently, to give guarantees whether he will comply. And you can see what that is. Chair, I have been before you with Mr. Zuma. And Chair, I haven't asked him whether I should tell you this, but let me tell you, in the time since Mr. Zuma was here, called in that particular way, he has had 2 moments of serious illness, for which you saw the need that you would meet his doctors. And dare I say to you, Chair, had you met his doctors, your entire approach to how he is communicated, how he is talked to by your Professor Musala or somebody else would be different, because you would know what he was facing between September last year and now. The second incident is that Mr. Zuma, for reasons that probably did become public, changed lawyers in the middle of COVID-19. I only saw him 3 times since then. And when he changed lawyers, and those who are practicing advocates, who are not peddlers of narratives out there, know this. When your attorney is fired, you have no brief at that point. And for moments, for months of that exchange, and the interaction, the handover was difficult because of circumstances of the change of legal representatives and COVID. And so it's not true that there has been refusal. Up to now, I can tell this commission, as I make these bold suggestions, Chair, about how you've run this commission and things you've said, that Mr. Zuma, up to 10 minutes ago, still tells me he believes that this commission at some point must hear his version. And so there are circumstances, Chair, that happened, and I don't want to blame the commission, because we too are to blame as Mr. Zuma's lawyers, because there were problems on our side that just made it difficult for us to present things to you. So I want to dispel that notion. That's my argument against your assertion. He did not refuse to take the opportunity. And then, Chair, having dealt with the part about the selection of witnesses, the next ground you will see, Chair, is also that Mr. Zuma came to this commission, made serious allegations about this commission, factually, and what he thinks or what he thought then and still thinks today were problems with this commission that would have concerned you. And he apprehends that those themselves seem to have been ignored. The fact that he came here and raised serious issues about this place, this commission, being an extension, and I'm making no suggestion, Chair, about you and my learned friends. I'm saying it's not impossible, Chair. It's not impossible in politics that as we sit here, we are all pawns in a very big intelligence game. It's not impossible. We don't know that because we are lawyers. We don't know that world, the world of smoke screens. And I'm saying when a witness who's at the center of what you are investigating appears and says to you, do you know that you are presiding over a project whose outcome is to deal with certain opponents. And I'm not saying that version was necessarily correct. So a number of those were not taken up with him in the letters that we got.
Mr. Skakan, I'm
Yes,
sorry to
Chair.
interrupt you. I just want to note the second ground without going to the affidavit.
Thanks, Chair.
Do you want to just mention it?
Chair, it's the fact that he gave testimony, very serious testimony about what you are presiding over.
Yes.
And Chair, he is of the view that that was ignored, disregarded, ridiculed, because it does not align itself with the dominant version that was given by the earlier witnesses. Now, Chair, let me move to the comments that you've made.
Yes, well, just one point. The affidavit, I think, doesn't say what it is that should have happened between the time he gave evidence and now to reflect that the commission has not ignored it. Obviously, you can't give evidence, but I'm just raising that I've seen that in the affidavit.
Yes, Chair.
But I mean, you will remember, I allowed him, time to say what he had to say until he said, well, it's fine for now, I'll see some other time. So, and of course, one was going to wait for him to come back and then take it from there.
Yes, Chair. Yeah, it's difficult because we're both in a precarious position of having to give it, but let me risk it. Chair, I said in this commission that there are times when I personally feel the right hand does not know what the left hand is doing. And I think, Chair, there is a way you and this commission can assure him that you are investigating the claims, your investigators are investigating the claims that he made about how we are here, that this is the grave to bury him. I'm not saying that is necessarily true, but that's the allegation he makes. And I'm saying, Chair, I challenge you and this commission and its investigators who sit behind it, whether they have gone as gung-ho as they have on the claims made by the sweetheart witnesses that I referred to and the claims he made. And it's this commission that can assure me that the claims that he made are being investigated. And if that is done as the chair did about his presentation, I'll be the first to say that ground is not good.
Yes, no, that's fine. Last week, I think on Friday, the witness, or at least one of the witnesses, the only witness, I think, who was giving evidence was Mr. Zuma's former attorney, Mr. Macha. And evidence had been given that affected him in relation to when he was chairperson of Denel. And evidence had been given from last year to the effect that certain executives were suspended at Denel, and the board that he was chairing was involved, and that they were suspended for no reason. It was part of getting rid of people who were not prepared to do certain wrong things and so on. So last year, we tried a number of times to get Mr. Mancha to file an affidavit and respond to the allegations or evidence by Mr. Saluji, for example, and so on. But he didn't. So when he came to give evidence on Friday, and then I think he came after there may have been a Regulation 10.6 directive issued. He then said they were dismissed for misconduct. And then he said, put up a certain story about what they had done. And I said, I just wish he had responded last year, because at that time, we still had a lot of time to investigate what he was saying they were dismissed for. But he was now telling us, towards the tail end of the lifespan of the commission, some of the investigators are gone, others are still happy to do whatever. So sometimes there are challenges when things come late, but I'm just mentioning.
Chair, I assure you, as I did now, that this is not brought frivolously. And also, may I place this for the record? I think, Chair, you've had a difficult time because people don't cooperate with investigations naturally. And Chair, when we come and make these grounds, these are not sweeping grounds about the fact that in every respect, I think in 90% of this commission, it has done what it can in a very difficult political context. I do not underestimate that. The point I'm making is this, is that with the witness telling you what he did, and with the circumstances I have told you, Chair, and I think, Chair, if you frank with me, that undertaking ruling of yours to meet his doctors, I know you were reluctant, but I think, Chair, you missed a golden opportunity yourself, just like we've missed our golden opportunities. Because I think this belief that he doesn't want to come here, and that all of these delays since September last year were because Mr. Zuma is ducking and diving. Others are even making attempts at history, that it's Stalingrad. But it's not that, Chair. And so we make that knowing all of those difficulties. And Chair, as I said, I still say today, this commission has missed the opportunity to get, well, not missed, it's not the right word. The central issues in your terms of reference is the Guptas and what is alleged to have happened and must be investigated, and the centrality of the head of state then. Chair, you're going to finish this report with no version from the Guptas, right? And I understand the legal issue that, well, if you don't give me your version, I'll just do. But sir, without the version of such people, I appreciate the fact that it weakens the commission. Without Mr. Zuma giving a version here in an environment that he trusts, the report may be great, may be good, but it may not assist in going forward, and it may open itself up to difficulties that we do not need. I have raised it with Mr. Pretorius that, if we were playing the Stalingrad, everyone thinks Stalingrad means a delay. Stalingrad was the shortest battle. It was just fought strategically. Is this: if you blow us today, you don't agree with us, as I said, I have a mountain to climb, what happens? Do we get Mr. Zuma here as a guarantee? No. If we approach it that way, we will just, even if we lose, we will review you. We will go as far as wherever, and that's not helpful. If you force me to bring him here without the climate being created for him to believe that he's not being judged, well, I'll put him there, Chair, and he'll exercise his rights to say nothing. And I think those two things, as strategic as they may be for me as a lawyer to get my client out of this place, I think the country deserves a climate that can interrogate this subject matter without judging the people we already dislike. And I think that's the pattern I'm giving without judging you. It's a pattern that I'm giving not just to you, because we have investigators, we have evidence leaders who have their particular styles and prejudices and beliefs. And I'm suggesting that there's a way to protect a process like this because it's big. And so when Mr. Zuma raises these issues about your comments, some of your comments look mild in a situation where the person is not an accused. But I'm going to take you to your comment when Barbara Hogan was here, Ms. Barbara Hogan, for instance. We set it out there in the paragraphs that are in, but eventually, at some point, you say this to Ms. Hogan. We have this,
so
Chair.
we are on comments now.
I'm on comments, Chair.
Yeah.
Your
okay.
comments.
Okay. Shall we take that as the third ground or what? The comments?
Yeah, your comments.
Yeah.
Just your comments in general, and the pattern of your comments and what apprehension they may raise.
Okay.
It's paragraph 53.2 for affidavit.
What paragraph?
It's 53 of the affidavit,
Yes.
point 2.
Okay.
Chair, I'm going to read it for you.
Okay, no, that's
I'm
fine.
going to read the particular comment, not the whole excerpt.
Okay, okay.
With Ms. Hogan having said this to you at some point, and I quote, "The president is a genial person, we know that. I cannot put aside the fact that probably dealing with women who held views might have been an uncomfortable experience for him. But I was careful to be respectful all the way through." Right? And Chair, after that you say this. But on the face of it, it seems to me, and you are free to comment, it seems to me that unless you tell us something else that happened that might have a bearing on this, it seems to me that what you were told on the phone by the former president amounted to saying Mr. Marocha was going to continue as CEO of Eskom, and there was nothing really to be done about, as far as the president was concerned, about the board's view that he had offered to resign, and they had accepted that. Chair, I know that you said it's better to have a judge who tells you what he thinks, and I accept that you may well say, I express what I think on this issue. The problem with putting a proposition, because it looks like a proposition from the judge, it's not volunteered by the witness. It's extracted out of the witness by the chair. And so that proposition on its own gives the impression that the chair has a particular concluded version or proposition to make to the witness. Now, I appreciate the fact that you have a role to ask questions, but I think it is in the nature of the questions and comments. The second one.
Well, before you go to this,
yes.
Is that the second one on the passage or another passage?
No, well, not on the part, we can deal with the passage.
Oh, okay. You see, I think what was happening here is I had listened to the witness. She had said certain things about what Mr. Zuma had said to her in a telephone conversation. And I sought to clarify from her whether my understanding of what she was telling me was correct. And you will see that I say, on the face of it, this seems to me to be what you are saying. But also it seems when she responds, it's quite important, it seems important. She doesn't say, yes, that's what I mean. She says, that is one possibility. Certainly. Another possibility is that she puts another possibility, which might mean I sought to have clarification of what she meant, and in responding, she said, well, it could mean two things. I just mentioned that.
No, Chair, I think you're correct. I think, Chair, these are not open and shut questions, but that is the danger of a presiding officer putting a proposition rather than, I will never fault Mr. Pretorius for putting a proposition. You are a very powerful man sitting there, Chair. And when you put a proposition to witnesses, once they assume, especially if it's a proposition, once they assume that the chair is with me here, it's one of those things you can leave to to the evidence leader, because that witness will lurch on what they think is your proposition, is your predisposition. And therefore, I'm not criticizing, Chair, that as a blanket issue, your comments are bad. I'm saying these comments that are put as propositions open themselves to the risk of witnesses who come here to take chances sent by as political missiles of others, offshoots of a particular agenda. And when they see that you put a proposition about the men they really want to see go down, they may latch onto that and think that's the route they want to take because the chair seems inclined. And even if, Chair, it's not your intention. And may I say this, one of the difficult things about recusal is also that who are we to know your intentions? One of the things missing intellectually in the debate about recusal is how do we determine that someone can say, you know what, I am biased. Say, I did not come here to present expecting that answer to anybody, not because you have no integrity, because human beings have a very low capacity for self-reflection because we don't see ourselves. So, Chair, I'm saying that comment on its own, not with the background I've given, may look mild.
Okay.
The next one, Chair, you say, did you get an impression that there might have been private meetings between the President and Mr. Maroja? Chair, we put that with the others because there again, a proposition is put. And it's a proposition in the context where this witness, of course, has come to tell you how bad Mr. Zuma is. None of them, they've all had come to tell you that, all of them, that they are perfect, he's not. And so, when you put that proposition, you actually plant in the mind of a witness as chair what I said, an understanding by that witness that, aha, here is the inclination of the chair. He thinks this, let me go there. And for a witness who's watching you, who's accused, about whom they are talking, spewing all sorts of things from their moral high ground, he sits believing reasonably, I think, that this is an engagement between you and people who are parroting a version that the Commission finds convenient. And then, Chair, she says, of course, exactly what I'm saying. She says, yes, and that impression, it is in paragraph, says something, I forget which paragraph. It's just the example, say, I underline that to show to you what political witnesses who come here before you, because all of them are, do to latch onto a proposition from you that they think is an inclination they've come to give you. And then later, Chair, you say this to her. Of course, it's polite, you have to thank her. But we say this because we also have noticed that those witnesses were treated with a certain level of deference about what they say. And then you say this, Chair, to Ms. Hogan right at the end, and I'm going to move away from your engagement with her. Thank you very much, Ms. Hogan, for those words. She had just praised you, that she appreciates it, and thank you all for the remaining of these 3 days instead of one that was envisaged, all sorts of things. And then, Chair, you say this to her, thank you very much, Ms. Hogan, for those words, and I don't think that's our complaint. And I thank you on behalf of everybody in the Commission, all of whom appreciate your words. I have no doubt from the interactions that I receive from ordinary South Africans every day, whether I am in a mall or in any public space. And for many South Africans who happen to have a way of sending messages to me, the messages that I get from them are amazing. The sentiments that you have expressed about the Commission, I can assure you that they are shared by very, very many ordinary South Africans Of course, a very great number of South African population is Christian. And so there are lots of people who say, we are praying for you. Chair, it goes on and on. I mean, what is the complaint about this polite engagement? Is that, Chair, having the context of your discussion with her and what seems to be your inclination and your kind of consideration of the approval received from outside the four corners of this room itself appears, I will not use the word improper, appears irrelevant to say to this witness, you thank because of how you are appreciated when you walk down the mall and all of those. And so read that whole paragraph without taking you, Chair, we've underlined it. The point we seem to make, we want to make is that comment and the others we will refer you to, Chair. The next one is Mr. Godan, paragraph 53.6. And we say it was more evident when Mr. Godan was here. It was obvious that the chairperson seemed to accept his bona fides and viewed him as a conveyor of universal truth about state capture. And then Mr. Zuma says in the affidavit, I do not say this lightly, but rely on the transcript which reveals this disturbing deference to Mr. Godan. In particular, this is where the comment of the chair to him. Thank you. You may be seated. Thank you very much. Before Mr. Pretorius begins, I just want to thank you, Minister Godan, for coming forward to assist the Commission. We have been making a call to all South Africans who may have information about the matters that we are investigating to come forward, and we have made a call to President, past ministers, deputy ministers. And then at the end, and we are grateful for that, and we are grateful that you also have come forward. Thank you very much. Viewed on its own, that's not a problem. But you've said in that comment to him that there are people who've not responded, including the president. And so the comment to him, that deference to him, and the comment that we've made a call to the president is in line with what I said is false, that he doesn't want to come. And therefore it gives that impression. And then you say to him...
You refer to the president or...
Yes, you do.
To president. I think that must... Well, I'm not sure, but I'm thinking may have been presidents, past ministers, I'm not sure, but one may have to...
That's why I said...
I doubt that I meant a specific president. I doubt that. But
Chair, I won't doubt your. Yeah. But I'm saying that is the risk we face. Is that I have to present to the very person, the only one who knows his intentions.
Yeah.
Then, Chair, you say, okay, that paragraph appears to me, and you must tell me if you understand it differently. Appears to be an acknowledgement by the ruling party that the leadership structure that it had up to that stage were failing to arrest corruption. And these are the practices that are mentioned there. Is that your understanding of the paragraph as well? Now, this comment is similar to the one I was saying about Ms. Hogan, where you make, it's a question, and I know in many, Chair, you say if, and you say, the prima facie view or whatever, but the fact of the matter, I would like the chair to read them together with an open mind and see what impression they give. And then after, at the end, you say that, now straight about, we have no doubt here that which president you meant. Unlike the other paragraph, you say, yes. I take it from what you say in paragraph 34, last sentence, in the event it would appear that he ignored the suggestion. I take it that the former president did not articulate his views in regard to the suggestion you made about what processes you were thinking.
I'm sorry, where are you reading now? I want to check this time because of the reference to president.
Yes, Chair. It's okay, Chair, let me give, if you go to paragraph 53.6 of the affidavit.
Yes.
and go down to the comment
Oh, okay, yes, now I see.
at the end of the
Yes,
next
yes,
page.
yes,
Chair.
yes.
And there can be no doubt which president you meant here. You say, I take it from what you say in paragraph 34, last sentence, in the event it would appear that he ignored the suggestion. I take it that former president did not articulate his views in regard to the suggestion you made about what process you were thinking should be followed. And then he says, and I'm reading both because of what I say witnesses are likely to do when they think you're so inclined. Well, in the event it was ignored, I think, well, at that stage, and then Mr. Nene needs to tell you what followed after the elections. Chair, those two comments, that exchange between you and Mr. Godan, of course, he, as much as you phrase it as a question to him, but he sees an opening about your inclination. And I'm not talking about your intention. I'm saying he sees an opening in your comment about the president who's not there. And so that comment itself is phrased as a proposition that may give, well, that does give reasonable apprehension to the person, a witness in the position of Mr. Zuma.
Of course, when one looks at excerpts or extracts from transcripts such as this, it's important to have the whole context, because this would have been an exchange when a witness is on the witness stand, and that witness has put in an affidavit where he has told the story. And it may be that a question is put in a certain way because everybody understands what's written in the affidavit. So it may well be important to have that affidavit in order to have a full context of the extracts. Yeah.
We do, Chair.
Yeah,
We do. I think Chair should be comfortable that we've read and we followed and we watched that interaction.
Okay.
And so we're not taking this out of context.
Okay.
And as I say, I want the Chair to look at them later with an open mind and connect them and say, and it may well be that the Chair, because only the Chair knows his intentions, will tell me that's not what I intended.
Yes.
And I have no way to dispute that.
Okay.
And then, Chair, that interaction with him, I would like the Chair to go through it. I don't want to read these excerpts because what I say, what I submit, they indicate is a mind that is inclined to agree with a particular witness about another who's not there. And Chair, as you keep saying to me correctly, but I need to find out what's going on, right? Chair, I'm asking you to do something very difficult. It's difficult for me, it's difficult for you. Is that, as I said, I'm not asking you to go to the extremes. In those comments and those propositions, you will find that, because you're human, you will find that in the heat of things and the outrage that you feel about the testimony, because you're human, there's a line you may cross. And the crossing of that line is not because you are a bad person or you intend punishing people. It's because you are outraged by a particular, and I've seen you outraged in these proceedings, justifiably so sometimes. So I think, Chair, what I'm asking you to do is to look objectively at your comments from the position of someone who is accused, number one, whether we like it or not, in these proceedings. This was started to get him, and that's how he sees it. And so his position is important for the Chair to take into account. Don't take into account those who love him and those who hate him because they are pursuing something else. And then, Chair, you will see that paragraph 53.7 is another quote where you put, your view, it's expressed as a question. You say, would the involvement of the presidency, right at the bottom, at the foot of the page, of the presidents in the appointment or reappointment of members of boards, SOEs, have been a normal thing? Is that a normal thing or not? Now, Chair, that question, as I said, contains what outrages you, sounds like. The suggestion that the presidency would interfere, right? Because we're talking about accusations that were made before you that Mr. Zuma was interfering with boards of SOEs. So, seen in that context, he views this comment and many others as the chair's inclination to agree with these witnesses, and that you are disinclined to agree with the counterversion. Because, Chair, I think there is a counterversion in society. There is a counter-narrative that makes the entire body politic, and this process, which is to help policy making, must not be determined by the dominant views of what in South Africa is a dominant class and its media and their views. Is that if you want to get out of this morass of policy uncertainty, which is what your task is our ability to thoroughly interrogate different narratives that are out in society and how they lead to fraud, that you are to investigate, corruption, and this thing called state capture. I keep referring to it as a separate issue, Chair, because as a matter of political science, all states are captured. All states. The reason there's a contest between classes in society, even here, is that they are contesting to capture the state. Some for good reasons, others for bad reasons. So state capture is a notion that is weaponized, comes as a notion that is designed at a time Mr. Zuma must go. But what the chair is tasked to do is to cut the veil, go beyond the different classes that contest at the state since its inception, is to look at this state as we speak now is captured. This state, particular one, beyond Mr. Zuma, long gone, and elsewhere in Ukraine. But what the chair must look at is what do these forces do with the state? What is the fraud and what's the corruption? And I think these comments demonstrate a mind that has accepted a particular version that Mr. Zuma facilitated wrongful capture of the state, that whose intention was to
Let us assume that they reflect an acceptance of certain evidence that has been given. Would you accept that there would be nothing wrong with that if that acceptance is provisional? In other words, until I hear the other side, until I hear what has happened. In other words, well, maybe this version without contradictory evidence, maybe it's true, but I'll wait until I've heard all the evidence and I can change my mind. I'm open.
Yes.
In other words, isn't the fundamental thing whether whatever you think of a certain witness evidence at a particular time, that you must at least keep your mind open and be prepared to change whatever you thought once there is good contradictory evidence or arguments and so on.
Chair,
Yeah,
would I accept that?
yeah, I'm just posing
No,
that, yeah.
Chair, intellectually as a way of engaging people, I would accept that you may hear one version and agree with it, and then hear another. But here is where I part ways with your answer. Is that it's like that Mrs. Jones, Mrs. Mkhize I was talking about, who's sitting in court listening to a judge talking about the fact that she wants maintenance. It may well be that when you make a comment that you think she's a gold digger, you can say to her, you may persuade me otherwise. But it's no comfort from a judge to make that comment and say and give the explanation you're giving me. That no, sit comfortably there. I'm calling you a gold digger for now. But when you come, you may well tell me you are not. That explanation, Chair, it's sound, the explanation you give, but in an environment where you sit in that powerful position with people who sit here, others as heroes and others as accused, those accused persons do not feel that statement you make the way you say it, because for them it's not an intellectual engagement, they are being accused. And so I want you, Chair, I know it's your explanation, but I want you to look at it and see whether a judge can give that answer for commenting flippantly to someone and say, no, but I was still going to change my mind. I don't think it's a legitimate explanation to a witness.
Yes, of course, if we go back to our earlier example, much earlier, before tea break, and of course, when you make, how you make a comment is also important, If you talk about, if you contrast that example of a judge or magistrate who says, women are gold diggers, then you have another one who actually thinks like that inside but doesn't say it.
Both are wrong, Chair.
So that, yeah, I guess one needs to be sensitive.
Absolutely.
One needs to be sensitive to all of these things.
Chair, you've come to the nub. Maybe you've expanded without noticing. Unfortunately, you are no precedent. Maybe you've created precedent for this nebulous concept. Sensitivity. Because when we sit where we sit, it was not a flippant comment when I said there is something intellectually dishonest about the fact that precedent about this subject matter, we get it from people who are the subject of our criticism. They tell us how to criticize them. And so, Chair, you've come to the nub of what I think reasonable apprehension of bias stems from. It stems from a need for sensitivity. And the need for sensitivity, Chair, comes from a recognition of the tenets of natural justice. And that justice must not be done, but they must also be seen to be done. And so a witness may well, Chair, think of what you say differently if it's said by an evidence leader. So I'm saying, Chair, some of the propositions in your difficult job you're doing have been propositions that a small person sitting, and when I say small, people will say Mr. Zuma is not small. Chair, lawyers, we think our environment is easy because we are here every day. Everyone who's not a lawyer is small in an environment like this. It's intimidating. It's only nice to those who see their enemies squirm. But to a person who is an ordinary citizen, to sit in this room is no ordinary task. And so sensitivity, I wish you could bring that as an element that really, really pricks. That should guide how we deal with the apprehension of bias, that judges must be sensitive, even if they are correct. And all of these things you say here, by the way, Chair, I'm not suggesting they are wrong. I'm not suggesting you shouldn't believe them. But we don't express everything we believe. It's the reason we don't tell our grandmother his cookies are not nice. We just don't want to hurt them. So sensitivity is an important component of how to deal with small people in a powerful environment with a judge. Chair, all of those quotes, because Chair, if I don't want to, I assume you've read them.
I've read them, I can assure you.
And Chair, what I want to do to you for them, so that I don't take you through each one of them, I didn't come here to tell you misspoke, is that entire area in which we traverse your comments, I invite the chairperson to look at them the way you've just phrased why there is a need for sensitivity in an environment of this nature. And Chair, I want to suggest that we ask you to recuse yourself, mindful of the crisis it would create for this important task. And I said, Chair, we have two reliefs in our notice of motion. The second notice may seem, relief may seem contradictory to the first one, because, of course, we always put this as lawyers further and alternative relief. Chair, it's put more sincerely than we do it as lawyers out there, because when I say we, I think my client acknowledges this. He takes this stance reluctantly. He takes it because this place, even when he is ill, did not seem to believe him. They wanted, let's see the doctor. And so in a way, it may not have been the intention of the commission. But when you say to someone, no, you say you are ill, I want to check your doctor.
But I think we must talk a little bit about that, because
Let's do it.
I saw in correspondence and in the affidavit that I'm accused of having disbelieved or not believed that Mr. Zuma was not well. And yet my recollection that I never said anything that suggested that I didn't believe it. You referred earlier on to the fact that I reluctantly agreed to the offer to meet with the leader of his medical team. That reluctance, I think, was mainly about whether we should go that far. But my understanding was that Mr. Zuma and his legal team wanted that to happen. But I expressed my reluctance even when we came back. We discussed in chambers, but when we came back in the open hearing, I expressed that reluctance, but I said I'd accepted. Yes,
Chair. No, Chair, let me do this. Let me say that I don't think it would be fair to accuse you of having disbelieved him. I think if that was put in some letter, I don't think it's as clear as that. I think, Chair, it's a series of things in how he is treated when he says he's ill. Mr. Zuma won't be believed. Even I say he collapsed here, they will say he faked it. And so in a way, you are dealing with a situation where I think that reluctance of yours to do this, as much as it may have been misinterpreted, was that it was clear that saying Mr. Zuma is ill does not convince a judge or those in the forum. And therefore, that offer was made to say, we don't know. If judges don't believe when a former head of state says he's ill, when a doctor puts up something to say so from the state, well, they may as well have a meeting. But I accept, Chair, that on its own, I wouldn't like to question that, because you did say you were doing it reluctantly. And I think your reluctance, I would like to view it as having been in good faith rather than in bad faith. But Chair, yes. And Chair, so all of these comments that I want the Chair to look at, I raise them because I think you've helped me with the case now. That I think a lot of them, my submission is that a lot of the comments you made about which Mr. Zuma complained may not be because maliciousness doesn't fit, but may have been insensitive in circumstances of a witness who's come to what he believes is a slaughterhouse, reasonably so, by the way. And so, Chair, I'm not raising this lightly, I'm raising it. I made an example earlier, Chair, the difficulty of representing Mr. Zuma, and for him to be believed. A judge in this country has questioned my integrity in court for representing a client. Never happens to a white lawyer, but it happens to me. And I'm saying that on its own creates circumstances for him that he is disbelieved. I've just told this commission now that our second remedy, relief, demonstrates that this is an act of frustration with the process. But it's no act of defiance of you, Chair, or this country and its citizens who need to know. What it seeks is to correct an environment that I think has been distorted by your comments, and sometimes the excitement that I've seen when people cross-examine someone they think is a scum. And I think an environment must be created for you. Because, Chair, I don't care about the people who sit in this commission behind the scenes. When this commission is reviewed, Chair, us who are close to you, who've known you rise as a brother, you will be criticized, not them. Not the agenda they are pushing behind the scenes, ethnic or racial. It will be you who will be criticized, and they will run away, and we will have to defend you. And the point I am making is this. I am asking you, Chair, to look at your comments, but the second relief we seek there, I'm asking you, in your thinking about how do we remedy this situation, I said to Mr. Pretorius, I'm prepared to sit with him and look at how Mr. Zuma can have an environment here where the citizens who deserve his version can hear it. And I would like you, Chair, to creatively, together with all of us, look at that remedy and see, even if you accept that some of your comments may not have been appropriate or may not have been sensitive, I'm asking you in that second relief to look at creating an environment, not just for Mr. Zuma, maybe for others, to come here and feel they are not accused. And that is why I said to Mr. Pretorius, when lawyers sit and talk about remedy, we do that because we want to assist the judge to come to some sort of conclusion that is just and equitable. As I said earlier, I can sit down now, Chair, and you blow me, and I will review you, and it goes nowhere. It will be the end of Mr. Zuma, or I'll bring him here and tell him to sit there and say nothing. And that is a stalemate I can do. But it's unconstructive. And I want you to look at that second relief and see, having considered the things we've said. And Chair, I would like lastly to look at the statement you made this morning and see whether it's important for me and my client to look at those versions. And we will tell you probably tomorrow or any other time. Chair, I thank you for giving me this time. It's a difficult task. Probably no one has had to ask the second in command in the judiciary that they are doing a bad job.
Well, I can tell you that in 2.5 months' time, I will be finishing 24 years on the bench, and this is the first time an application is brought for me to recuse myself.
And it's brought by me.
It's brought by you. But, there's nothing wrong with an application for recusal when people feel aggrieved. It's a remedy that is available and should be considered.
Thank you,
but I was just saying that In 24 years, this hasn't happened, but there's always a first time.
In 20 years of practice, I haven't been asked to ask someone I know, I come from this village with, to recuse themselves. So I thank you for giving us the opportunity.
Yes.
And those are submissions, and we're free to have discussions with them. There's an affidavit we gave, Chair, to the extent that we take the technical approach about whose version in terms of Plascon events should prevail. I will hear it's there, but I would like some time to look at your statement, and we'll let you know.
No, that's fine. We are at 10 to 1. Thank you, Mr. Skakana. Thank you very much.
Chair, thank you so much.
Thank you. Thank you. Yes, Mr. Pretorius.
Chair, may I suggest that we take the long adjournment now and come back when you direct?
Okay, it's 10 to 1. Let's take the lunch adjournment and then come back at 2.
Thank you, Chair.
Yes, we adjourn.